welcome you all to the latest in Cornerstone Housing series of webinars this year. This is Housing Allocations, Avoiding the Challenge. And you have a panel of 3 barristers from Cornerstone. Myself, obviously, Catherine Rowlands. You've got Andrew Lane, one of our most senior members, who has got more cases to his name than I can care to recall. And you've got Tara O'Leary, who is more junior than Andrew, but nonetheless extremely talented and experienced in this area of the law. And between us, we have a fair amount of ideas about how to avoid challenges in relation to housing allocations. Although, of course, we're here to say you can't avoid all challenges. There's always going to be something. If we look at the next slide, we can see that we're looking at Part 6, the Housing Act 1996, and we're going to be talking about various judgments in relation to that. But before we start into the webinar as a whole, have a look at your screen. You will see down at the bottom, there's a chat box and a Q&A box. Please feel free to put questions into the Q&A box, and whoever's talking at any particular time will try and answer them, or we'll raise them at the end as an answer to be given verbally over the screen. And of course, if you do have any really weighty and meaty questions, do put them in a brief, tie them up with a pink ribbon and send them to us to give you formal advice on. We'll give you the details at the end of that, of this section. We will also be sending out the slides and a recording of this session, so you will have everything that we say and everything that we've written down easily to hand, sent out to you by way of an email afterwards. Our emails are also going to be telling you about various upcoming events. On the 4th of July, for example, we've got our public law teams seminars about public law, which nothing else happening on the 4th of July. You might as well join that one anyway. You know, it's going to be more interesting than whatever else might be going on. And then on the 6th of September, we have the next in our series of webinars on housing in particular. It's going to be tackling the issue of shared ownership, and it'll be Andy again talking to you about that. So going back to housing allocations, what we're talking about is a wealth of recent cases. If you put housing allocations in to Westlaw, you get that list of 8 cases. They cover all sorts of issues, including irrationality, error of fact, the ever ready question of Section 11 of the Children Act 2004 that people think has far more effect than it really does, and fettering of discretion in the context of, for example, the public sector equality duty. So we're going to be talking about some of those issues. We only have an hour to do so, so we'll go on to the next slide and give you the summary of what we're actually going to be breaking it down into. First of all, discrimination and the public sector equality duty, then reasonable preference, and then the extent of local discretion. There's obviously an overlap between each of those, but Tara's going to talk to you about discrimination. I'm going to come back to talk about reasonable preference, and then Andy's going to finish with local discretion. We are due to finish at 12. Hopefully we'll be tied up by then, but we are able to run over if you're able to stay. And as I say, use the Q&A box to ask questions as we're going along. Over to you now then, Tara.
Thank you very much, Catherine, for that lovely introduction. So I'm going to talk to you this morning about everyone's favourite part of public law and the way it overlaps with housing, which is, of course, the ubiquitous Equality Act challenges. So essentially, I'm just going to take a quick look at the main equalities arguments that tend to come up in the Part 6 context and how those arguments are presented, and then we can have a look at some slides which are kind of more focused on responding to and avoiding challenges. So on the next slide, please, Andy, just a quick reminder of what I expect everyone this morning already knows, which is, of course, that Part 6 itself says nothing about discrimination. Instead, we're in a position where we have to look at the overlap between the exercise of Part 6 duties and those which are derived from other legislation. Now, obviously, the Equality Act is not the only area of overlap. I think Section 11 of the Children Act 2004 is also one with which you'll all be familiar. But why does this matter? Well, going back to the case of Malcolm back in 2008, the predecessor legislation to the Equality Act 2010, but no doubt still of good application today, which is essentially that because Parliament has decreed discrimination is unlawful, when it comes to looking at an allocation scheme, the courts will not countenance actions which would replicate or give effect to unlawful discrimination, even if they don't amount to a breach of Part 6 itself. It is the overlap of the subsidiary sort of duties which can make the Part 6 allocation scheme unlawful. So on the next slide, we have, or I have set out sort of a summary of what I think tend to be the four most common arguments in the allocations context. I've left out Section 15, disability discrimination, which, as we know, tends to come up all the time, particularly in relation to possession or perhaps antisocial behaviour injunction proceedings, but less of a feature in the allocations context. So instead, what we have, I'm going to start with direct discrimination. And of course, this was the first and leading case on positive discrimination, which went all the way to the Supreme Court, involving, of course, Andy Lane. They couldn't have done it without him, and our colleague Matt Hutchings, KC. Many of you will remember this case from a few years ago. The Hackney Council had a nomination agreement with Agudas Israel Housing Association, which in practice only nominated or accepted nominations and to give its housing to Orthodox Jewish families. And the Supreme Court and also the European Court of Human Rights eventually held that there was no discrimination in that arrangement. After the Supreme Court, the applicant did apply for permission to try and take her case to Strasbourg, but that court ruled her application inadmissible in 2022. So she was a lady who was the single mother of 4 children, 2 of whom were disabled. They needed allocation of a large home and they had a relatively high priority, but effectively they were skipped over on a couple of occasions because properties belonging to Agudas Israel became available but were not nominated to her. They were given to Orthodox families. And she essentially said, well, that's discrimination, isn't it? Because, you know, I would have been entitled to that housing, but the only reason you didn't give it to me is because I'm not from an Orthodox Jewish background. So I think the message that emerged in my reading of these decisions, and obviously Andy is the expert here, but I think the court did absolutely contemplate that could amount to direct discrimination, and there's no reason in principle why it wouldn't. But it was found to be justifiable as a form of positive action, which can be permitted under the Equality Act, where actions are being taken to assist and try to achieve equality of outcome for very particular minority groups who are actively in need of assistance. And essentially, Hackney and Agudas Israel were able to justify their policies in this case by very good and clear evidence of the needs of the Orthodox Jewish community, which are quite numerous in Hackney itself. So there was very clear evidence of deprivation and very specific housing needs amongst that community. They tend to need very large houses with certain kinds of facilities near certain kinds of infrastructure in the community and so on. And there was also clear evidence of discrimination against the Orthodox community in the private rented sector. So those two factors put together meant that was a group that had very unique and specific needs. And in addition, the Agudas Israel housing stock only amounted to about 1% of all social housing in Hackney. And so those factors together meant that the discriminatory effect on people such as the applicant who were not Orthodox was extremely limited, and also could be justified as being targeted assistance towards a community in need. So an unusual, perhaps, case may come up again in other contexts, and very interesting, I think, in terms of what it might mean for positive discrimination in other fields outside the housing context. But I think that the arguments that you're much more likely to see coming up much more frequently, of course, are indirect discrimination, which I think tends to be a very common feature in allocations challenges. So I would say the leading case on this is the combined decision of the Court of Appeal in two combined cases, which was Mr. Gulu and Mr. Ward, and again, of course, involved our friends Andy and Kelvin Rutledge KC from Chambers. So indirect discrimination asks, I think at its core, the question, is the effect of a provision in the allocation scheme such as to put a protected group at particular disadvantage in comparison to applicants who are not in the protected group? And I emphasize the word effect of the provision, so that the PCP, provision, policy or criteria, because of course these provisions on their face are usually neutral and they don't intend to discriminate against anybody, but the way in which they're actually operated or implemented in practice can lead to different outcomes for different groups, and that's precisely where the indirect discrimination will arise. And when I mention protected groups, of course, I'm talking about groups who share protected characteristics, whether that's disability, race, and in this context, the protected characteristic of race will generally involve asylum seekers, refugees, or gypsies and travellers. And also sex, which will generally tend to overlap with questions relating to domestic abuse, perhaps also pregnancy, maternity, and children, because we know that I think a majority of applicants with children often involve single parent households who tend to be women. So the question is, does the effect of your PCP or your provision in your allocation scheme actually put that protected group to particular disadvantage on a comparative basis? And if yes, that means there is indirect discrimination, but the question is whether or not the local authority can show the disadvantage is a proportionate means of achieving a legitimate aim. So that argument succeeded in Gulu and Ward. Hillingdon's allocation scheme was held to be unlawful because it indirectly discriminated against refugees and travellers, gypsies. There was a 10-year local residence requirement, and although there was some exceptions to that requirement for certain cases, the exceptions effectively were held not to go far enough. Those groups, refugees and travellers, were less able or less likely able to satisfy a 10-year residence criteria. But the key point here, and I think this is the key to unlocking a good understanding of indirect discrimination, the reason that these groups couldn't satisfy that criteria or were significantly less likely to satisfy that criteria is because of their protected characteristic. So compared to UK nationals or people who don't live a nomadic lifestyle or people who've never had to move abroad from another country to escape persecution, they are much less likely because of their protected characteristic to be able to satisfy that. And this was a case where, interestingly, the local authority spent a lot of its argument trying to suggest that there was no comparative disadvantage, and that argument failed. And they had not attempted, as a fallback argument, to put forward justification for its policy. And so what's interesting about that was the court, when it came to making relief, did say that the scheme was unlawful, but said it's only unlawful unless or until the local authority is able to offer justification. So the court effectively sort of allowed the local authority a chance to justify its policy rather than having to simply quash it completely. I understand, I think Hillingdon did just amend its scheme rather than trying to put forward justification. Andy's nodding. But I thought that was it's an interesting point, and I think that approach to the grant of relief could be quite important in other cases. The case of TX and ADOR is one involving Catherine Rowlands, and her opponent was Lindsay Johnson from Chambers as well. That was one where a policy was discriminatory indirectly against victims of domestic abuse because the scheme gave its lowest priority to people who had proved that they had an overriding need to move into the district from elsewhere. And of course, a very large percentage of people with an overwhelming need to move into the area will be fleeing domestic abuse elsewhere and will involve a very large cohort of women. So although the policy appeared neutral on its face, it was indirectly discriminatory on the grounds of sex. Reasonable adjustments, again, kind of focuses on the question of whether or not an allocation scheme puts a person at a particular disadvantage in comparison to persons who do not share their protected characteristics. And if yes, then the local authority can come under a duty to make reasonable adjustments to ameliorate that disadvantage. the leading case here is the case of Noor and Birmingham City Council. There's two decisions which ultimately found that Birmingham's policy was both indirectly discriminatory and had failed to make reasonable adjustments for applicants with disabilities, specifically families who had adult, disabled and dependent children. The scheme and the way it was operated effectively failed to make an exception for dependent children who were adults and disabled, and effectively was barring people households who didn't have children under the age of 18 from bidding on certain properties. Now, no one from it's fair to say this didn't end well for Birmingham, this case, and I was tempted to make a joke and say that nobody from Chambers was involved in this case, and perhaps that was part of the problem. But I think what's interesting in terms of what this case says about reasonable adjustments is there was an argument about whether or not when a local authority operates an allocation scheme, it's acting under Part 3 of the Equality Act, which relates to public services, or Part 4, which is renting premises and effectively its role as a landlord. And the court ultimately concluded that in operating an allocation scheme, which allows applicants to apply for housing, it is operating under Part 3, it is providing a public service, and it's not acting as a landlord under Part 4 until it's actually signed the tenancy agreement and the applicant has become a tenant. And there's a very significant implication from that, because the duty to make reasonable adjustments under Part 3 is anticipatory, and it is not anticipatory under Part 4. A landlord does not come under a duty to make reasonable adjustments unless the tenant comes and asks for an adjustment to be made. In the public services context, as I suspect many of you, particularly acting on behalf of local authorities, will already know, because this will apply in all sorts of different local authority functions, the duty to make adjustment is anticipatory. So you have to think about what kinds of groups with what kinds of protected needs are likely to need to use your service, and make adjustments bearing in mind what they might require as a group. So the classic example, of course, is providing a copy of your allocation scheme in an accessible format online, whether that's by Braille or some other form of assisted technology. But in this context, in Noor, the court held that there had been a failure to think proactively about the needs of families with adult disabled children, to cater for them in any way within the scheme and when applying and bidding for housing. And that had put disabled applicants at substantial disadvantage in a way that could not be justified. And then the P.S.C.D, we could do a whole session on that alone, and I'm not going to summarise the principles in section 149 today, I don't have time. But this is, again, an argument that tends to come up all the time in the allocations context. Sometimes it is the only challenge that's raised, perhaps particularly shortly after a scheme is adopted or introduced, but very often it goes hand in hand with other challenges which allege indirect discrimination or reasonable adjustments. And we'll certainly see that defending these arguments, if you have a good P.S.C.D, you'll often have very good defence to indirect discrimination arguments as well. So these arguments are often very much hand in hand. H and Ealing was a case involving Matt Hutchings, I believe, a case where two priority schemes had been created, putting aside 20% of lettings to working households and model tenants. And it was challenged on the basis that the P.S.C.D in support of that decision had been defective. The Court of Appeal eventually held that the scheme was lawful and the P.S.C.D assessment was adequate. And from a local authority perspective, some helpful language from the Court of Appeal that a relatively broad brush approach to a P.S.C.D can be compliant, and also that looking at facts and figures about your lettings and so on is not a precise mathematical exercise, and the local authority does have to make some broad assumptions about how its scheme will affect different groups. We see the opposite in C in Islington, which is a case which found that a scheme did in fact unlawfully discriminate against victims of domestic abuse, because it did not award extra points for living in unsettled accommodation to people who were living in domestic violence shelters. say domestic violence, because this is before the Domestic Abuse Act came into force. But it was in that case, interestingly, the court found that the discrimination was proportionate, justified, and therefore lawful. And there was also no breach of the PSCD because, first of all, helpfully, the scheme made express reference to ongoing monitoring. So Islington had committed to reviewing the operation of its scheme at regular intervals to identify whether there was any unintended consequences of its scheme. Secondly, there was favourable provision elsewhere in the scheme for victims of domestic abuse. So even though the scheme didn't do the thing that the applicant wanted it to do or said it should do, there was other provision elsewhere to make sure that persons in her position could access housing and would have some degree of preference within the scheme. And those two things put together led the court to conclude there was evidence that the local authority had in fact rigorously and carefully considered the various protected groups, including women who were victims of domestic abuse, and had thought about them, had recognised them, and had sought to cater for them within its scheme. And that was powerful and persuasive evidence that there was no breach of duties. It was just simply that the local authority hadn't done what the applicant would have preferred it to do, but it had in fact catered for her group. Gulu and Ward, I've already said the scheme was quashed and unlawful, but I just want to highlight that decision emphasises that the PSCD involves a duty of inquiry. And so there is a duty to proactively, when you are about to amend or adopt your scheme, to identify what protected groups might be adversely affected and to consider what the impact of the scheme on them will be. And frankly, that is your opportunity when you come back with that analysis to look at whether there should be adjustments to the scheme and whether you need to tweak things or whether you need to cater for certain unintended consequences that your initial PSCD might have identified. So on to the next slide, please, Andy. So what do you need to go and address these arguments? Well, the proportionality test I've set out there it's very well known. It's helpfully summarised in Acomb and Livingston, which is a Section 15 disability discrimination case, so not directly relevant. But the question is whether or not the least intrusive action has been taken and whether or not the action taken strikes a fair balance. It's obvious that in an allocations context, it's always about balancing competing interests. And so the question is whether or not protected groups have been recognised and there's been an attempt to balance their interest against the needs of others. Because, of course, we know that if provision is made for one group, it simply means taking provision away from another group. What evidence do you need? Well, as I say from a moment ago, what you need is evidence the local authority has considered and recognised the existence of groups like travellers, victims of domestic abuse, children, elderly people, etc., and has sought to accommodate their needs in some way. And then it must be the needs that are connected to their protected characteristic. And we see the same thing in the Islington case. This is the question of flexibility across the scheme. So you can absolutely point to other provisions in your scheme which cater for these groups, even if you haven't met their way in the way that the applicant says you should in a challenge. Gulu specifically comments on the very obvious observation that all these arguments are connected. Indirect discrimination and reasonable adjustments are both justifiable on the basis of proportionality. And so clearly, if you can point to a good equality impact assessment that shows compliance with the PSCD, you will almost always be able to point to justification for indirect discrimination or a failure to make reasonable adjustments. And Gulu effectively sanctioned that sort of looking at the evidence in a global context. The duty of inquiry, I've had the pleasure or misfortune, I don't know how to describe it, of drafting equality impact assessments a couple of times for local authorities in the allocations context. And it is a technical exercise and it does require you to delve into your facts and figures. I mean, you should be going to your lettings statistics, perhaps from the last 5 years, perhaps from the time when you've most recently reviewed or adjusted your scheme. You need to be looking at how your scheme is actually operating perhaps several years down the road. And you need to be looking at the equalities data that you collect from your applicants. So who are your applicants? What are their protected characteristics? How many of them have disabilities? How many of them have children? How many of them are over the age of 65 or whatever it is? And that might also involve drawing on information from your nomination partners who will themselves be able to give you information about your housing stock. And that is how you're able to come up with an understanding of who your applicants are and then how they are treated in comparison to other applicants that do not share their protected characteristics. Because we know that the indirect discrimination argument particularly, and also reasonable adjustments to some extent. It's a comparative exercise. So it's meaningless to look at your applicants as a whole. You need to understand how disabled people are treated vis-a-vis non-disabled people and so on. So please do be proactive about drawing together those figures and keeping track as well, because it's no point, in the newer case particularly, there was criticism made of Birmingham because their scheme had been enforced for 4 years and nobody seemed to have looked at how it was being operated or to have realised the detrimental effect that was being caused to applicants with adult disabled children. Next slide, please. I'm going to rush through the last couple of slides because I'm out of time, but I just wanted to point out this idea of please don't close your eyes and ears. Just because your EIA might have been compliant at the time you completed it doesn't necessarily mean that you can then forget to consider equality issues ever again. The Gulu case is quite helpful here because it said that there's no duty to conceivably hypothesize every single imaginable group who might come forward when you're drafting your EIA in support of an amended scheme. So I think the example Gulu gave was that there was, Hillingdon was under no obligation to consider the position of Aboriginal Australians who might apply for housing in its district. But that position changed when Mr. Gulu came forward and identified a problem which applied to the refugee population. And it was at that point that an onus arises to reconsider the PSED and to think about amending, adopting or justifying your scheme. And so that it's not a once and for all thing. These duties are continuous. And again, as I said, the newer case. So please keep an open eyes and ears. And then the final slide is just about refusing relief. So even if you do find yourself in a situation where a challenge has succeeded, there are circumstances in which you might persuade the court not to quash your scheme completely. So obviously our old friend section 31, if it's highly likely that the outcome for an applicant would have been the same, even if, for example, there'd been a compliant PSED assessment, no need to grant relief. I mentioned already Gulu and Ward, where the court granted the local authority an opportunity to justify its policy, just to perhaps counterpose that with Newer, where that opportunity was given and that led to the second decision, which held that Birmingham was unable to justify that particular policy. So do be careful about whether or not it's a good idea to try and take up that opportunity. And then Ealing, where Ealing very much came along to court and sort of threw its hands up and said, sorry, yes, we now look back and can see that our initial PSED assessment was flawed, but in good faith, a review was underway and they were transparent and cooperative about that. And so the court found that there would be no benefit to quashing the scheme as unlawful. Sorry if I've run on a little bit long, and I'm going to hand over to Catherine. Thanks.
I'm going to be talking about reasonable preference, which carries on from what Tara was just saying there about trying to anticipate who might be affected by your allocation scheme. I'm aware that the title of this webinar is trying to avoid challenges, but that's never going to happen because there's always going to be someone who comes along and says, well, hang on, I should have a higher preference. And indeed, people that say other people should have a lower preference. Nobody is going to be able to draft an allocation scheme that makes all the people happy all of the time. So the best that a local authority can do is draft a lawful scheme that tries to anticipate as much as possible how it's going to work, how to strike the balance between everyone who wants to get one of those rare and valuable things, social housing. And what the Act says, a bit of a reminder on the categories of reasonable preference, which I shall refer to for the sake of brevity as RP. The Act says in section 166A3 that there are the following 5 categories of RP. And you will notice that you've got 3 categories that overlap a little bit to start off with. So you've got people who are homeless within the meaning of Part 7 of the Act. That's everyone who's homeless. A lot of people, when I'm working on draft allocations policies, say, well, we don't want to give people who are intentionally homeless any priority. We don't want to give those who are not in priority need any reasonable preference. You've got to, even if that's just like 1 point in your point scheme or 1 little boost up in your banding scheme, there's got to be some reasonable preference for everyone who's homeless. But then the Act goes on to say at B, specific categories of people who are owed duties under section 192, 1932 or 1952 and who are occupying accommodation secured in relation to homelessness applications. So you can be homeless and therefore in category A and category B owed reasonable preference. And if you look at category C, people occupying in sanitary or overcrowded housing or otherwise living in unsatisfactory housing conditions, you might think that those people would be entitled to say that they're homeless as well. So you might have another overlap there. They might be in C, B, and A. And indeed, when you look at category D, people who need to move on medical or welfare grounds, including grounds relating to disability, so people might not be able to carry on living in the property that they're in because of those issues, and might also be homeless for that reason. And people who need to move to a particular locality in the district housing authority where failure to meet that need to move would cause hardship either to themselves or to others, perhaps because they're offering or receiving care from somebody in that particular locality, or in relation to jobs or things like that. And so if we move on to the next slide, Andy, please. If you look at the Code of Guidance, Chapter 4 and Annex 1, Annex 1 in particular gives you more examples as to how those categories D and E work. And it also emphasises that there's no need for cumulative preference. So if you're giving someone extra points because they're homeless, you don't also have to give them extra points because they're homeless and owed the duty under Section 1932, and because they've got medical needs, and because they are living in unsanitary accommodation. You don't have to add everything up and make sure that somebody with multiple strikes gets to the top of the list. How you give your reasonable preference, how you strike that balance between everyone wanting social housing, is a matter for the local authority. You've got to try and predict how your scheme is going to work. And as Tara's already said, that doesn't mean to say you have to sit down and try and imagine every possible combination of factors that might appear, but you have to do your best to try and work out what's likely to happen. And as Tara has also said, you have to review it over time to see how it's working and make sure that you have got that balance struck correctly. In the Housing Act 1996 Additional Preference for Armed Forces Indeed Regulations of 2012, there are a few extra suggestions of further categories of people who are entitled to RP: former members of the armed forces, people who are serving members of the armed forces who've been injured, and bereaved spouses of members of the armed forces. So these need to be written into a lawful compliant allocation scheme. But reasonable preference just means a reasonable head start. Doesn't mean a guarantee of an allocation under the policy. You can't say, I am homeless, I have a medical need, I am living in insanitary accommodation, I therefore have reasonable preference, and therefore you must give me accommodation now. That's not how an allocation scheme works. It just means that you get a bit of a boost up. You may lawfully stay on the waiting list for the rest of your life and not have a complaint about the lawfulness of the allocation scheme. And on the next slide, please, Andy. The allocation scheme, as Tara's also already touched on, sits at the location where various duties of local authorities cross over and intersect and overlap with each other. So obviously you've got housing is the main thing. But when you've got things like medical need for RP or in sanitary accommodation leading to RP, you're into the care and health aspects of things. So you might have medical needs to be assessed, you might have care needs to be assessed, you might have the impact of housing on those needs to be assessed. You're also talking about immigration status, asylum seekers, other PSED factors, and you've also got the localism factors that Andy's going to be talking about later on, how you want to use your allocation scheme to shape the people living in social housing, boosting people up the scheme, dropping people down the scheme, and all of that has to work together to create a cohesive whole. And what the cases that we've been looking at really show are, it's where those factors intersect and sometimes conflict with each other that you do get challenges being brought. So I'm going to look at some cases in particular. On the next slide, please, Andy. first case I want to look at is a case of Willett and Eastbourne Borough Council. This is a fairly recent one. It shows you the overlap between allocations and the rights to be on the scheme with localism issues and also PSCD issues. So we've got 3 issues here coming into play in this scheme. So this Willett had a history of antisocial behaviour and had been, in the end, subject to a possession order made against her. She also had mental health problems and was possibly autistic, and she was excluded from Eastbourne's allocation scheme. She was homeless, the result of a trial at which her disability had been fully explored. She'd run PSCD as a defence. The outcome had been the council had been found to have acted reasonably in seeking possession against her. So she was homeless, and therefore she comes in the RP categories. But the flexibility remains in an allocation scheme to downgrade somebody, even if they've got RP. So RP bumps her up, but her ASB bumps her down. And at the end of the day, Eastbourne's decision to carry on excluding her, despite all these issues, despite her reasonable preference, was lawful. The interesting thing I found in this case was a decision by the court that it is not right to say that to be lawful, an allocation scheme must build in a residual discretion so that the local authority can say, well, I will just allocate something to somebody if I feel like it. There is no requirement for a lawful scheme to include that kind of residual discretion. Just to emphasise the point that you can't avoid challenges, she also ran an argument to say that her scheme was not clearly enough delineated, and that was also rejected. In Jaberi, we had this mix-up again between homelessness and allocations, and again PSCD and disability issues, and indeed immigration issues, because Jaberi was a refugee. He has serious epilepsy issues and also mobility issues. He applied as homeless to Westminster in 2018, and they accepted the main housing duty because he lost his previous accommodation, having just been asked to leave by a private landlord. They provided him with TA, which was on 2 floors, had internal stairs. He can't manage the stairs, was effectively locked upstairs. Westminster accepted he needed to move, and he was put in priority band A for a move in interior terms, i.e. in terms of temporary accommodation. They then offered him an 18-floor flat. Somebody with mobility issues always worries about an 18-floor flat, what's going to happen if the lift doesn't work, but also in his case, what's going to happen if he needs to be evacuated. On several occasions, he'd been shipped out of a flat on a stretcher, which might not fit in the lift. So he was worried about that. By the time of the hearing, the flat was in the process of being adapted for him, and it hadn't been done by that time. So he had sought to review its suitability for him. County Court appeal was lodged. And so he was on the brink of being rehoused by Westminster. But at this time, he brought a judicial review for breach of the statutory duty to provide accommodation under Section 193. The court accepted that because he was about to move, there was no current breach, there had been a historic breach. On reasonable preference, he complained that the allocation scheme was not lawful because, whilst he had priority for a move to temporary accommodation, he wasn't entitled to priority for permanent accommodation within Westminster. So he was bumped up the TA list, but down the permanent list. Because he was a homeless person, his reasonable preference was recognised by Westminster by giving him 150 points. He said, I've got medical priority. That gives me 200 points. I get to choose, he said. I want the 200 points, not the 150 points. Westminster said, no, you're homeless. We're being subject to a separate statutory duty to accommodate you as homeless. So we're going to give you 150 points. And there was a lot of discussion about whether the difference between 150 or 200 actually amounted to a hill of beans in any event. But Westminster points out that the people who do have both characteristics have a route out of their accommodation that they say is unsuitable for them because the local authority is under the duty for them as homeless to secure suitable accommodation. And so on the next slide, the court rejected the claimant's case that the allocation scheme was not lawful in relation to reasonable preference. An allocation scheme has to be framed to recognise the RP categories, not to give anybody absolute priority. No guarantee of an allocation. And there's no need to give somebody with 2 reasons to have RP priority over those with only 1. And he had his reasonable preference recognised by being given the 150 points. To say to them, which one do you want? You get to pick, would be an absolute administrative nightmare. If you look at this Westlaw, you will see that there was an appeal lodged and permission was given. It's now been compromised because Westminster have now offered him all singing, all dancing accommodation in which he's perfectly happy. And just again to emphasise, there's always going to be something that somebody can challenge, and this was a case where it's that man again, Lindsay Johnson. He's always going to find something to challenge. He also argued that the defendant was a pretext duty under section 166A9A Roman 2 to publish as part of their allocation policy information as to how long it's likely to be before accommodation becomes available. Of course, you can't ever say you will get accommodation within 13 weeks, 4 days and 7 hours. It simply can't be done. And Westminster subsequently defended that challenge successfully. Andy, can you take me back to the next slide, please? That's just a quote from the judgment there. It may be incongruous that a person who's got medical need will get fewer priority points if they're also sadly unfortunately being homeless as well and in TA, but the approach taken by Westminster was clearly rational, and it was proper for them to proceed on the basis that it's going to do what it's supposed to do under the statute, and it knows very well that it will comply with that. Next slide then, please, Andy. And the next one. You just can't get the staff these days, can you? So I'm going to move on to the judgment of the Court of Appeal in Campbell and Ely, which is a really interesting case on the junction between the Care Act 2014 and the Housing Act 1996. And this was a case where the court was particularly considering section 23 of the Care Act 2014, which says that a local authority under Care Act duties can't do anything it is obliged to do under the Housing Act. So the claimant in this case has visual problems, he also has OCD, he also has depression, and it's accepted that he's a disabled person, so PSCD applies. He was initially housed by Hillingdon under Part 7 in temporary accommodation, but Hillingdon discharged duty, and Lambeth, because they'd been placed in the Lambeth area, Adult Social Care took over funding of the same accommodation, exercising the power under section 19.3 of the Care Act, which provides power to a local authority to meet urgent care needs before carrying out any assessment or financial assessment of the person with care needs. They then carried on and did a Care Act assessment and found he had eligible needs, so they owed him the Care Act duty. But he declined a care package. All he wanted from Lambeth at that point was accommodation, and his Care Act needs were being met by his family and friends. He was then moved on to a guest house, then to B&B accommodation, and he just didn't like anything that was offered to him as temporary accommodation. So he did apply to go on the allocation scheme, but he didn't actually bid for properties on the waiting list. And in the end, Lambeth got tired of waiting and decided to cease funding the TA. This was challenged by way of judicial review. He argued that he needed accommodation plus, as it's called, that is to say, care and support that requires accommodation in order to be effectively delivered. The defendant didn't accept that and argued that he did not have a care need, which was a care need for accommodation. Next slide, please. He said his medical needs meant that he could basically circumvent any allocation scheme. He said he was never going to get to the top of the waiting list under the allocation scheme, but he had serious care needs, so he needed accommodation, so the local authority could skip the allocations and just give him one under the Care Act 2014. But he did not succeed in that argument. His reasonable preference did not mean that he was entitled to something that the local authority should do under the Housing Act 1996. Section 23 says you can't do that. So providing accommodation is a housing need, not a Care Act need, and therefore reasonable preference doesn't amount again to a guarantee of accommodation. And on to the next slide. Quick look at, oh, sorry, I thought I had one more slide. Never mind, I shall shut up now and hand over to Andy, which I think is probably a good thing in relation to timing in any event.
Thank you very much, Catherine, and apologies for my malfunctioning of the fairly easy process of just pressing the button. I got rather excited. And thank you obviously both for Tara and Catherine for the excellent explanation as to the two key issues of Equality Act and reasonable preference, which override and involve some of the main areas that any local authority must be looking at, both in the formulation and operation of their allocation schemes. What I want to do in this hopefully fairly short end session is, in a sense, reset slightly what we've heard so far, and of course heard it in the context of challenges to local authority allocation schemes and decisions thereunder, and stress really the flexibility available to local authorities. I mean, you did hear, of course, Tara earlier referred to flexibility and referred in particular to the C in Islington case, dealing with the domestic violence issue on that issue. But I want to stress that this is really about, these days, local authorities, in principle, with certain constraints, being able to formulate their own schemes. And that, as you can see there, sounds very simple, because the Localism Act, in other words, from January 2012, local authorities have had discretion to be much more precise about who gets on their waiting lists. Before that time, I could have gone to my local authority and put myself on the waiting list, and they would have put me on there. And you'd have had local authorities with tens of thousands of people on waiting lists, many of whom had no housing need whatsoever, or maybe even had moved away. I well remember doing a judicial review permission hearing where somebody was on the scheme previously, I think it was Brighton, but lived in Edinburgh, but just liked the idea of being in Brighton. When they changed the scheme because of the 2011 Act, she didn't like that, and she felt she should still be able to go on Brighton's allocation scheme, despite the fact that she had no connections with Brighton, and therefore she felt that, well, that doesn't matter, I want to live there maybe in the future. And of course, her application was rejected, because one of the things the Localism Act does do is, of course, give local authorities greater discretion as to how they deal with these matters. In particular, from those provisions, particularly 146 and 147 of the Localism Act. 146 introduced, crucially, Section 160 ZA of the Housing Act 1996. And those of you who do a lot of this work will know that that's the section that deals with eligibility, of course, which is an immigration question, which has a particular interest at the moment with certain EU citizens and the question of the operation of the withdrawal agreement, but also, of course, introduces the notion of qualifications. In other words, there are certain people who cannot, whatever you want to do, get on the scheme because of eligibility requirements, but those people that you may choose, you don't wish to prioritise or even allow onto the scheme. Section 160 ZA allows you to do that. Section 147 introduced Section 166A, from which you've already heard from Catherine about reasonable preference, but also other crucial provisions, which I'll briefly mention later. So in terms of wide discretion, what do we mean? I've highlighted 3 different areas. I mean, there are many other examples, including in case law, but what you'll see is Section 159, and this is all, of course, Part 6 of the Housing Act 1996, talks about local authorities being able to allocate in such manner as they consider appropriate, which of course sounds wonderful. Section 159 also provides that you must comply with Part 6. In other words, for example, the restrictions on qualifications, the questions of reasonable preference, the questions of additional preference, the adherence under Section 169 of statutory guidance, they all must be considered and followed insofar as you need to. But other than that, you can devise a scheme in such manner as you consider appropriate as a local authority. Section 166A(11) again talks in similar terms by saying that you may as an authority decide on what principle the schemes is to be framed. In other words, let's take a broad brush approach and say politically you want to particularly support carers, or you want to particularly support people fleeing domestic abuse, or you particularly want to support low-income households of people who are still living at home. I don't want to sound too bitter about that. If you've got adult children still living at home, that may be something that the local authority wants to encourage low-income workers to be able to have social housing. So you can certainly decide that, but what 166A also says, apart from the reasonable preference matters that Catherine dealt with, it also shows that you have to have a scheme, because you can't just decide not to have a scheme. You have to have a scheme. You must explain the policy, and therefore you can't just say this is what we're doing. You must explain why you're doing it, which is why any allocation scheme that you see will always have an introduction section explaining what has been considered, such as the Children Act 2004, such as the statutory guidance, such as the Equality Act, and so on, and also what priorities one is given. And of course, 166A, as I say, is subject to the reasonable preference requirements, which, as Catherine says, doesn't mean you're going to get a property, and nothing in the allocation scheme law allows you to say, I'm going to get a property. It's just about allowing you to get on the scheme and to be treated fairly as part of that process. And as I say, the last bit of Section 166A, it basically says that subparagraph 14, you can only allocate in accordance with the scheme, which pausing there just means that you have to be reasonably flexible in the sense that there's always going to be circumstances outside your control, which you weren't, emergency cases where you weren't really kind of anticipating. And therefore, most schemes will have some get out, allowing, I suppose one could call it management transfer, but certainly something allowing in very precise and rare circumstances allocations to be made, either by named officers or named committees. And you'll also see there the statutory guidance talks about the power to determine which applicants do or do not qualify. And when you say statutory guidance, we know that as with Part 7 and homelessness, it's something which a local authority has to have regard. But we are talking, I think it's 5, and I may be corrected on that. I think 5 bits of guidance. We start off with providing social housing for local people in 2013. We have the right to move and social housing allocations in 2015. We have improving access to social housing for members of the armed forces in 2020, improving access to social housing for victims of domestic violence in 2022, following the Domestic Abuse Act of 2021, and the allocation of accommodation guidance for local authorities, last updated in 2023. So there's all different provisions which need to be looked at and need to be considered when one is looking at formulating and applying a scheme. And that therefore must be seen in that context. And I've given the example there from the Providing Social Housing for Local People guidance, which talks about the Localism Act giving back to local authorities the freedom to better manage their social housing waiting list. And with greater flexibility to enable them to tackle homelessness by providing households with suitable private sector accommodation. One may recall that when this was coming in, and when in particular private rented sector offers were very popular, I mean, they probably still are in certain areas, under the Part 7 provisions of homelessness, you had a lot of local authorities who preferred to deal with their homelessness, particularly the priority need homelessness, by allocating private sector accommodation rather than effectively allowing them to be prioritised for Part 6 accommodation and social housing, either from the local authority or from those housing associations to which they had nomination rights. And that's something that in principle was, if not encouraged, but certainly allowed by the government in trying to encourage the housing to be for people from a particular area. What I would say also is that there is sometimes a misconception about this guidance in terms of when you do have a residency requirement. Sometimes people say, well, the guidance talks about 2 years. Well, it talks about 2 years as being, in saying that local authorities are encouraged to have a residency requirement, they talk about it as being at least 2 years. And therefore, I've seen ones which have been justified beyond 10 years. So it can be done, although the higher you get, the more you require in terms of numbers. So if you require 10 years, you're going to have to make sure you have sufficient exceptions to avoid the kind of the Gulu and Ward problems about people who, through no fault of their own, cannot acquire or are unlikely to acquire such periods of residence in one area. And as I say, the 3 common qualifications you will find: housing need, residency, and behaviour. Housing need obviously relates to people's income, people's assets, and obviously people having their own property. So if I own my own property, I'm not going to be able to go on the waiting list because I don't have the housing need, and it's almost certainly going to be a qualification requirement that I must be without such an interest in property. Residency requirement I've already mentioned. Most authorities, when they draw up a post-Localism Act allocation scheme, have had a residency requirement, generally speaking, requiring people to have lived in the borough, sometimes in neighbouring boroughs as well, for a period of years. And that can be, and I've seen them from 2 to 13 years. That is normally a requirement. And behaviour, obviously you're talking about people going into social housing, whether that's assured tenancies with housing associations or whether that's secure tenancies with local housing authorities. Well, in those circumstances, if somebody's just been evicted from their property because of antisocial behaviour, you may not necessarily want to give them social housing so that they become your problem. And therefore, it's perfectly in order to certainly restrict people who have had perhaps in the past, and you've obviously got to be a bit careful as to what you mean by the past, but in let's say the last 5 years have had injunctions or possession orders for such behaviours against them. What I would also say is 2 things on this slide. Firstly, with behaviour, or indeed any of the requirements, it used to be thought that, well, if I've got a reasonable preference, so in other words, the list that Catherine came up with at section 166A3, I therefore can't be excluded from the scheme because of I don't have the housing need, or I don't have the residency requirement, or I don't meet the behaviour. That's not necessarily true, and we saw that with one of Matt Hutchinson's case recently, and I think it's 2021, which is the Montero and Lewisham case, which effectively said that no, you can have something that excludes a reasonable preference person. What you can't have is something that excludes en masse. So in other words, if you just say, if you've got an injunction for antisocial behaviour, you don't qualify to go on the waiting list, well, that's not likely to involve many of those people who are in the reasonable preference categories, and that is fine. If you say, conversely, that you must have a 15-year residency requirement, that could exclude a lot of people in one of the reasonable preference categories. And without the kind of assessment that Tara talked about, equality and also the review of the operation of any scheme, it might be difficult to justify. And that's why you tend to find the longer and more stringent requirements, such as that, have exceptions to make sure they don't fall foul of either the reasonable preference or the equality provisions. Other qualifications are family associations, perhaps. sometimes employment, particularly low-paid employment, and Section 166A, subparagraph 5 of the 96 Act does encourage prioritisation based on financial resources, behaviour and local connection. The last thing, I think it's probably the second last thing I said on this slide, is just to say that there are such things as local letting schemes which are perfectly lawful. In other words, you can have a particular area, for example, rural villages is often the example given, where you can give priority to those with a local connection, particularly if there are people, for example, in that area who are having difficulty finding accommodation even though they work in that area. That is possible as long as it's obviously not discriminatory and you've carried out a proper assessment. And that's why you have to be aware of certain things. And I'll rush through this slide because we've dealt with most of it. Reasonable preference and additional preference, Catherine dealt with. Discrimination, we've heard from Tara on that. Statutory guidance I've already mentioned, and Tara also dealt with Section 11 of the Children Act 2004 and the public sector equality duty. So generally speaking, obviously things have to be in line with those issues. The clarity issue is important because you've got to make sure your scheme is easy to follow. And by that, what I mean is that if you follow it in a certain way, the court may say, well, that's not how it should be interpreted, because the ultimate arbiter of how you interpret your allocation scheme is the court, not the local authority. So please make sure if you have a scheme, it is clear as to who qualifies and where they go in terms of the banding or the point system that you operate. And Montero and indeed the case that Tara mentioned of Muir and Birmingham both give credence to that approach. So try and make sure it's a clear scheme which is easy to follow and understand. You also have issues of Section 166A(12), which is the fact that you need to consider your homelessness strategy. This is where people go scrambling around to see if they've got a homelessness strategy. You should have one every 5 years. Your tenancy strategy, to be honest with you, that's probably less important. That would involve things like the length of tenancies. Those authorities silly enough to have flexible tenancies, what their policies on renewal of those tenancies and such like. And if you're a London borough, you have to consider the London housing strategy, which was last produced in May 2018, although the evidence based has been updated. I think it was on the 2nd of November 2023. So you need to consider that in formulating the scheme, and obviously make sure there's a coherence between your various policies. You also need to make sure that, as I say, there are exceptions available. We've already had explained the Z and Hackney case, where certain exceptions can be made. And you have the awful situation with Grenfell, of course, where the local authority had to kind of very quickly adopt policies to deal with an urgent situation, albeit those policies were challenged in terms of the question of a couple who had separated and whether the person who was without the accommodation was entitled to the same size accommodation that he had left. In other words, the same size as his partner and children were living in. So one has to look at those circumstances and make sure that the matter is adapted. As for the guidance, I've already mentioned the providing social housing for local people guidance. It just says at 19 that it's important that housing authorities retain the flexibility to take proper account of special circumstances. Something like Grenfell, of course, was hopefully not something that's going to be repeated. But of course, there are other issues such as domestic violence and violence generally, and people fleeing that violence, people's need to move away, or maybe even situations where homeless families and care leavers are coming back into the authority. Those are the kind of situations where you may need to make, for example, exceptions to your qualification requirement and need to consider those matters. Domestic abuse, I've already mentioned. The Domestic Abuse Act doesn't impose any statutory requirements as such on local housing authorities with regard to Part 6, but it does strongly urge and encourage, and quite properly so, the fact that people should be not held to the same qualification requirement, for example, if they've had to flee an area and they are therefore ordinarily won't satisfy the residency requirement of the new area. It encourages that factor to be taken into account, and you'll see that from the statutory guidance on the left of that screen. I then finish with Lord Neuberger. Not a bad thing to finish with. And what he says is that, however, what is important is to emphasise that once a housing allocation scheme complies with the requirements, what was then 167, which is now primarily 166A, but generally Part 6, and any other statutory requirements, the court should be very slow to interfere on the ground of alleged irrationality. The only caveat I would give to Lord Neuberger's very wise words is that it's like a lot of judicial review matters, and I've got one tomorrow on a homelessness matter. You often find courts say things like they should not be trying to nitpick decisions and not try and go line by line, word by word on a local authority decision and then do exactly that thing. But it is something that you're entitled to say that it is our decision as to how our scheme is operated. And really, I think the things I would really stress is what Tara stressed at the end of her session, which is ongoing monitoring. I appreciate it's in the context of the Equality Act, but ongoing monitoring. It's silly if you don't know every year how people are being allocated the properties, what banding they're being allocated from, who aren't being allocated the properties, and who are effectively, for example, are there effectively redundant bandings? I mean, one of the Hillingdon cases was that, and complaints was that people were being put into a band where they were never going to be allocated a property. So keep that under review. And in particular, you need evidence and justification, review and refreshment that Tara talked about in those two slides, which go beyond the equality issues, as I say. You need to be able to justify that. You need to carry out regular equality impact assessments. And if you do that, of course, it may, as has already been explained, enable a court to say, well, look, you're entitled to introduce these qualification requirements, but you need to keep it under review to make sure it isn't going to be discriminatory or it isn't going to exclude a reasonable preference group or subgroup. And then if you can do that, and if you can justify that with good, sound logic and figures, then you've got more chance of overcoming any challenge. As has been said before, I think particularly by Catherine, you're never going to stop a challenge, but it's going to at least make it more difficult. And in terms of reading, I can't go backwards, I'm afraid. So, can actually. Oh, good Lord, what skills I've developed. There is this wonderful book by one of our brilliant colleagues, Sarah Salmon, on a practical guide to housing allocation schemes in England. It may take longer than an hour to read, but it is full of proper and important information. So please feel free to do that. And I'll pass you now back to Catherine, who looks astonished I've actually mentioned her.
Yes, thank you all for staying 10 minutes over time. I hope you've enjoyed it, and thank you very much for the Q&As that you've given us. We've answered most of them, and as I say, if there are any more, any small queries, do drop us a quick email. If there are large queries, drop us a brief. We have other members of Chambers, of course, who are equally adept in advising on allocations policies. I'm delighted to talk to you. We will be emailing out all the slides. A recording of this will be available on our website very shortly. Remember the Public Law Day coming up on the 4th of July. And do get in touch with us if there are any other topics you would like us to cover in future webinars. 6th of September for shared ownership with Andy. And who are you speaking with on that one, Andy?
Lois Lane, no relation.
But it'll be a super session, I'm sure. And so with that, I think we'll bring this session to an end. Thank you very much for attending. And we hope you've enjoyed it. Good afternoon.
Thank you very much. Bye-bye.